All right, the court is calling 2017 CR 13698 State versus Adriana Tanahara. Could I have parties announced?
Megan Galloway for the state.
Elizabeth Russell for Miss Tanahara.
And are you Ms. Tanahara?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision and state's motion to supplement pending motion to revoke probation with your attorney, and did you understand it?
Yes, ma'am.
Are you the same Adriana Tanahara who's placed on community supervision in 2017 CR 13698 for the offense of forgery of a commercial instrument or check on August 3rd, 2018 for a term of 4 years? Is that you? All right, state.
Violation of condition number 38. On or about the 25th day of August, 2020 in Bexar County, Texas, the defendant, Adriana Tanahara, did then and there fail to participate in the felony drug court program in violation of condition number 38.
How do you plead to that? True or not true?
Not true.
State.
We waive and abandon the remainders.
Any objections to the waivers?
No objection, Judge.
Did you understand by pleading true to violation of condition number 38, the court could find it true, grant the motion, sentence you to 2 years in the state jail facility and up to a $500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 38?
Yes, ma'am.
Court will find violation of condition number 38 true. Is there a proposed agreement?
Judge Astute is asking for revocation and a sentence of 1 year in the state jail facility.
And Judge, that is our agreement, if I may speak on behalf of my
Yes.
client. Ms. Tanahara was originally placed in the drug court program. She was having financial difficulties with participation. When she was removed from the drug court program, she started to have medical issues, congestive heart failure. I have some documentation of that congestive heart failure if you'd like to review that. As her medical condition got worse, she became more and more concerned about turning herself in because she wasn't going to get her medical treatment.
Mhm.
She understands that this was not the appropriate way to handle this, and that because of that, she only can be either terminated, unsatisfied, or revoked. But she is here wanting to take responsibility, and I do think she wanted to address the court really quickly, if she may.
Do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Adriana Tanahara.
All right, your attorney mentioned something about financing.
Yes, ma'am.
How was that related to drug court?
I was just unemployed. I wasn't applying myself as I should have been. And since then,
No. Because it seems as though
Mhm.
maybe a conversation that you've had, you're saying that you had issues with finances in felony drug court. And normally felony drug court does not require you to pay the $1,000 fee until you're closer to graduation. So I'm wondering, just so I'll know,
Mhm.
what finances are you saying you had difficulty with in felony drug court? Because they help you
No, I
with
didn't have
employment.
that. And not in the drug court. I had it
No.
in the program, I guess, that they offered me the last.
What program?
My probation officer had called me and told me that there was a program I could pay off my fees in a certain amount of months. And
What program?
I don't know what it was called.
So two things, Judge. How I was addressing the drug court was that she was not able to provide for herself, not provide for the drug court
Okay.
because of financial issues. So that's issue number one.
And then
Um, And then issue number two is that according to my client, the felony probation officer told her that if she was able to just pay off her fees, they would terminate her from probation. I know that that's not necessarily the way that it works, but that's how it was discussed with her. And it's not the first time I've heard that being discussed with the client. So I think just for court's clarity, I think that's what she's speaking about.
Okay.
And let me give you the documentation on the medical.
And then my other question is, it said that you owed $743.99 to HEB. Has that been paid?
Yeah, ma'am.
I'm sorry?
No, ma'am, not yet.
All
It
right,
was
you've
this week
had
being paid.
since 2018 to pay that. Why hasn't that been paid?
I wasn't always employed, but it was not my fault.
But I mean, it's since 2018 and you haven't paid a penny to that?
Take
That's a problem.
responsibility. Yes, ma'am.
And then this is not your first motion to revoke. That's a problem.
Understand.
So what have you done? Have you done anything other than this is your second motion to revoke?
I've just got employed. I mean, I've just, been trying.
I mean, if you haven't done anything, I mean, just tell me.
No, ma'am, I haven't done anything towards the courts. You're right.
Because you were placed on probation before I was presiding judge in this court. And then you had a motion to revoke, and it was violations of 5 and 5. And according to this, you have children. That's why I told you to do parenting classes.
Okay.
And it appears you haven't done anything since 2018.
You're right. Sorry.
I mean, I don't even know. Somebody explained to me why I should give you a year instead of 2 years because you haven't done anything.
I guess the basis of our request is the congenital heart failure and the medical treatment that you would receive in the state jail facility. She hasn't done anything towards the courts, but she did at one point receive gainful employment, and that was a huge struggle and a huge hurdle that had to be overcome by Ms. Tanahara. I think you can see based on her drug court participation as well as even the medical documentation, she is a methamphetamine addict and has struggled with addiction for quite some time. And so even just getting gainful employment was a feat in and of itself.
And who's taking care of your child?
I think it's her mom. Is that
That's my sister.
your sister? And they're here, Judge.
So does anybody want to tell me why I should just give her a year? She hasn't done anything. I mean, not even paid towards HEB since 2018.
And so our request would be based on the medical issues as well as the fact that she did seek gainful employment. We understand that this is not the way Ms. Tanahara should have handled this. She understands that.
State,
Judge, I did take into consideration the medical issues, which is why the state has been asking for 2 years of this.
all right. Are you asking me to follow this revocation for 1 year?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, this is what the court will do. The court is finding violation of condition number 38 true. The court will grant the motion, revoke, sentence you to 1 year in the state jail facility. Give you credit for any time served. There's to be restitution to HEB in the amount of $743.99. And that's under cause number 2017 CR 13698. There's to be no unsupervised contact with minors. And the court will request the therapeutic community for you. Therapeutic community doesn't increase the amount of time that you will serve, but it is designed to help you with any addictions you may suffer from.
On my way out of my room.
During that the therapeutic community is in the state jail facility.
All right, did you review the document entitled Fraudulent Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. With your heart condition, if you continue to use, meth is not great for the heart to begin with, not even on a healthy heart. One or two things going to end up happening. Either you're going to be in and out of jail or in and out of prison for the rest of your life, or either you may get a bad batch, or it may hit your heart a certain way, and somebody's going to have to identify your body. If you're not going to be clean and healthy for yourself, then do it for your child if you love your child.
That's fine.
And when you're released from the state jail facility, don't come to your sister's home acting like you've been the parent all the time and you're setting your own rules. You're going to need to flow with the way the household is set up. Do you understand?
Yes, ma'am.
All right, when you're released, if you cannot find a place to help you with your sobriety, any type of transitional home, if I'm still here, you come back here, I'll pick up the phone, call a place to help you, all right?
Appreciate that.
All right,
Thank you.
good luck to you, okay?
Thank you.
You're welcome.
No.
Thank you. Yes.
Very quick question. We got a plea coming up. The victim wants the victim impact statement, but she can't make it in. Can she zoom in?
Yes.
Thank you.
And Rick, she can do that, or if you want, we can do sentencing today and have him brought back, however he wants to do it.
Okay. We'll let her know. Thank you.
Oh, Rick, could you do that to probation?
Yes.
Thank you.
You're welcome.
Anyone else ready? Yes. 38,000 pages.
That's right.
Oh, thank you.
Good morning, Judge.
Good morning.
May I approach you have a moment?
Sure.
This is an off-docket topic, everybody's favorite. I've conferred with the state. Mr. Allen is in custody in LA County and Los Angeles. The state is looking to dismiss he went into an airport with a gun about 2.5 years ago. He's joined the military. They're looking to dismiss it as long as I provide proof that he paid his TSA fine, but I can't get that to them right now. So the request would be to have a bond set. The state is not in opposition to that. They've kind of looked at it and they're trying to figure out if they can dismiss it.
Imani Robinson. And that's MTR PSI.
MTR.
Oh, I need the paperwork.
Sorry.
Oh, that's okay.
Off right. Sign. Just step out, yeah. Step on back line. Just make sure you speak up, ma'am.
All right, is this still gonna be a contestant?
No, Your Honor. He's going to enter a true plea. We have an agreement with the court set on his condition.
Okay, I need a trial court certificate.
Just have a seat.
Oh, she can remain here and you
Okay.
can just go grab it. Oh, yeah. Okay. All right, they're going to go get that. While she's getting that, we'll begin. Court is calling 2024 CR 008-663 State versus Imani Robinson. Can I have parties announced?
Galloway for the state.
David Andre Woodard from Ms. Robinson.
And are you Miss Robinson?
Yes, ma'am.
If you review the documents entitled motion to revoke community supervision and first
We're on the
amendment
record.
motion to revoke thank you. To revoke community supervision with your attorney, did you understand it? Okay. Are you the same Amani Renee Robinson who was placed on community supervision in 2024 CR 008-663 for the offense of theft of property less than $2,500 with 2 or more convictions on December 5th, 2024 for a term of 4 years? Is that you?
Yes, ma'am.
State?
Violation of condition number 4 in Bear County, Texas, the defendant Amani Renee Robinson did then and there fail to report to the supervision officer as directed for the months of May, June, July, August, September, and October 2025 in violation of condition number 4.
How you plead to that, true or not true?
True.
Judge, we even abandoned the remainder.
Any objections?
No objections, Judge.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you to 2 years in the state jail facility and up to a $2,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Judge, this is the defendant's first MTR. We are asking that the court deny the state's motion and alter and amend her conditions to include the hostility management course and a no contact order with Talon Mackey, and that is TALIAN MACKEY.
All right. So why hasn't she reported?
Judge, when I spoke with Amani regarding not reporting, I think what happened is the new offense had occurred. She knew that she would likely have a warrant, and I think she got fearful of reporting to probation. So instead of doing what she should have done first, we're here now in this motion to revoke with months of not reporting. As the state mentioned, this is her first MTR. She has been on GPS monitor since the court set a bond for her, and she's had no issues on the monitor. So we're respectfully asking the court to follow the state's recommendation and try to get Ms. Robinson back on track so she can successfully complete her probation.
How old are you?
29.
All right, I'm gonna give you a choice. These are your only choices. There are no other choices. 1, I can revoke you, and if there's no objection, I'll sentence you under 1244 to 300 days in the Bear County Jail. Or 2, I continue you, and as a condition of your probation, you're gonna do some jail time. And it'll be 30 days jail. Which do you prefer? You need to discuss that with her.
I would like to, Judge, before she makes a decision.
All right, thank you.
Let's go ahead and see.
And say, I'm sorry, I'm making an assumption you have no objections if they choose the 1244 route. All right. Anyone else ready? Please go to my hand. I'm sorry, who?
Thank you.
And Norma? On Antonio Damian Margarito, that needs to be reset. I think his attorney is out, correct? Page 3. His attorney is out on leave.
Yes, ma'am.
What date do you want to recall that? Yeah, that's fine. Damian Antonio, if you'll come forward, please. Damian Margarito Antonio.
Very question, just make sure you speak up right there by the black line. Yes, sir.
Hello,
Thank you.
hi, your attorney is actually on leave, so we're gonna bring you back on January 15th. Do you have any questions?
No, ma'am.
All right, once you sign the reset form, you'll be excused. Just have a seat. The coordinator will call you for your reset.
I appreciate
All
that.
right, thank you.
Working on two, please,
Thank you. And Norma, that client, he is PTD. Mhm. Joseph Rodriguez. Oh, you were not here on time. Are you all ready?
We just turn in the paperwork.
Oh, they're not completed with the paperwork yet, but once that's done, I'm just calling the people who were not.
So you don't
on
need
time.
a.
No, we don't need him on time.
Okay, I'm sorry about that.
No problem.
I'll start.
And deputies, when y'all get a chance, could you bring out Francel Brax, please? He's on, oh, Brax, hi. Mr. Brax, have you had contact with your attorney
No, ma'am.
at all?
No, ma'am.
All right.
Be ready on Ms. Robinson.
All right, she'll come forward. We're back on the record in 2024 CR 008663. So counsel, what has your client decided?
Which decision are going to do?
On the record, let's keep it down.
30 days and continue on 300 days.
I want to be my 300.
All right. Oh, do you have the,
I think you have turned it into your first.
all right, can I have a trial court certification, please? All right, court is finding violation of condition number 4 true. Court will sentence you under, well, the court will revoke sentence you to 300 days in the Bear County Jail under 1244. Give you credit for any time served. There's to be no contact with Don and Ben's, BEN apostrophe S. There's to be no contact with Talon, I believe it's Talon McKee.
I believe that was the name the state put on the record, Judge.
All right, is there anything else with regards to sentencing?
No, Your Honor.
All right, let's review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney. Did you understand it and did you sign it?
Yeah.
Yes or no? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thanks, Judge.
Thank you.
Let's begin with case 1. In this case, the defendant stood before the judge after violating probation. The court had already shown leniency once. Probation is not freedom, it's structured mercy. But when someone fails to follow those conditions, the judge is forced to ask a simple question: is this person willing to change? What stood out in this moment wasn't shouting or chaos, it was clarity. The judge calmly laid out the reality: you were given an opportunity and you didn't use it wisely. This is where many people make a critical psychological mistake. They see probation as a second chance instead of a final warning. When accountability feels optional, consequences become inevitable. The emotional lesson here is ownership. High-pressure moments test whether someone accepts responsibility or shifts blame. Growth begins the moment excuses end. Now let's move to case 2. This courtroom exchange escalated because of attitude. Tone matters. Body language matters. Judges are trained to read more than words. They read posture, eye contact, and compliance. In this case, the defendant's responses signaled resistance rather than reflection. Here's the key insight: authority figures respond to respect. When someone reacts defensively, especially in a legal setting, it often triggers firmer enforcement. The judge's patience narrowed as the defendant's posture suggested defiance. Many viewers misunderstand these moments. They think the judge is being harsh, but in reality, courts operate on structure. Disrespect in that environment signals risk, and risk changes outcomes. Emotionally intelligent individuals understand timing. There's a time to argue and a time to listen. A courtroom is not the place to test power dynamics, it's the place to demonstrate maturity. And that brings us to case 5, one of the most revealing moments of the session. In this family violence case, the judge made something crystal clear. This wasn't just about punishment. It was about patterns. When someone admits they react first in anger, that statement carries weight. Impulse control is one of the strongest predictors of repeat conflict. At one point, the judge firmly stated, "There's no hugging up in this courtroom." That wasn't about cruelty. It was about boundaries. Courtrooms symbolize order. When physical closeness appeared casual in a serious case involving violence, the judge re-established structure immediately. This case also included strict conditions, deferred adjudication, required classes, no contact orders, and housing restrictions involving minors. These weren't random limitations. They were risk management tools. Here's the deeper lesson. The legal system doesn't just punish behavior, it evaluates future danger. When someone demonstrates emotional volatility, the court imposes guardrails. Across all 3 cases, a pattern emerges. The biggest turning points weren't dramatic outbursts. They were decisions. Choosing not to comply, choosing to respond with attitude, choosing not to control anger. Every consequence flowed from those moments. Psychologically, high-stress environments amplify character. When pressure rises, people revert to habits. If those habits include deflection, pride, or impulsiveness, the cost multiplies quickly. But there's also hope inside these stories. Each judge offered structure before punishment. Each defendant had a moment where a different choice was possible. Each case reminds us that discipline is often the last barrier before irreversible consequences. The most powerful takeaway isn't fear of jail, it's understanding that emotional regulation determines outcomes long before a sentence is announced. If you want to avoid courtrooms in your own life, learn to pause before reacting. Learn to accept correction without ego. Learn to treat second chances as rare privileges, not guaranteed rights. Because in real life, just like in these cases, the judge isn't the only one evaluating your decisions. Your future is too. And every choice, especially the small emotional ones, is building it in real time.